the promise of regularizing staff with temporary status. My respectful submission that this is a fraud played upon by the government on all these people who have been working on daily wages or on contract basis. Last year, an announcement was made that they would regularize people with 7 years of service, and a notification to that extent was brought out. Honorable Speaker, I will present that notification on the floor of the House. This was in pursuant to the demand which all of us made that we should regularize people who have got at least 10 years. So government said we'll give them for 7 years. Now this is called a daily wages grant of temporary status scheme of Government of Goa. This looked to be that government was really fulfilling the wishes and the demands of the people. But Honorable Speaker, may kindly look at 2.5. Such daily wages who acquire temporary status shall, not however, be brought onto the permanent establishment unless they're selected to regular selection process for Group C posts. This is completely wrong. Now please turn over to the third page. That is another number 5. Despite conferment of temporary status, the service of daily wager may be dispensed with by giving a notice of 1 month in writing. A daily wager with temporary status may also quit service by giving a written notice of 1 month. And please look at 7. An undertaking shall be taken from all the eligible employees that they shall seek no additional benefits from the government once covered under the scheme and are willing to avail benefits as specified in the scheme. This is completely a dishonest approach, Honorable Speaker, because what does the Supreme Court say on this? Honorable Speaker, a judgment, latest judgment of the Supreme Court of 2025. Please see para 1. When public institutions depend day after day on the same hands to perform permanent tasks, this is a judgment of Dharam Singh and others versus State of UP, 2025 live law, SC 818. So para 1, when public institutions depend day after day on the same hands to perform permanent tasks, equity demands that those tasks are placed on sanctioned posts and those workers are treated with fairness and dignity. The controversy before us is not about rewarding irregular points, it's about the years of ad hoc engagement defended by shifting excuses and pleas of financial state can be used to deny the rights of those who have kept public institutions running. We resolve it by insisting that public employment should be organized with fairness, reasoned decision-making, and respect for the dignity of work. Please look at paragraph 4. It tells the background. I won't read everything, but please read 4.7 down. By the judgment dated, did you get that, 4.7? The learned single judge of the High Court dismissed the petition, holding that no rules for regularization in the Commission had been shown, that even assuming the 1998 regularization rule applied, there were no vacancies for the appellants. Moreover, the single judge held the regulation was impermissible in view of the law declared in Uma Devi and allied precedents. It was also observed that the petitioners had not specifically essayed the subsequent decision, so and so. The appellants preferred special leave before the division bench, affirmed the dismissal. Now please look para 6. The question before us whether the High Court erred in failing to adjudicate appellant's principal challenge. Para 7. Having heard the learned counsel of parties, we are unable to endorse the approach adopted by the High Court. Para 8. The state's refusal of 11/11/99 cites financial constraints, and the subsequent decision also taken after High Court decision reconsider adverse to financial crisis and a ban on creation of posts. Neither decision engages with relevant considerations placed on record, namely the Commission's 1991 resolution repeated proposal acknowledged administrative exigencies of recruiting body, handling large cycles, the continuous deployment of these very hands for years, and the existence of the attendant work that is primarily perennial rather than sporadic. While creation of posts is primary and executive function, the refusal to sanction posts cannot be immune from judicial scrutiny for arbitrariness. We believe that a non-speaking rejection on a generic plea of financial constraints, ignoring functional necessity of the employer's own long-standing reliance on daily wages to discharge regular duties does not meet the standard of reason. Moreover, it's undisputed that the nature of work performed by the appellants, that is sorting and scrutiny application, dispatch of and office support, driving, has been continuous and integral to Commission's function since the engagement between 1989 and 92. Commission itself moved for sanction of 14 posts and furnished a list of 14 daily wages, including the appellants. That consistent internal demand coupled with uninterrupted utilization of appellant labor on regular office hours, 45 seconds, the duties are perennial. Go to paragraph 17. So the High Court rejected that first there were no sanctioned posts. that the Supreme Court rejected that there were no sanction posts that would be financial burden. Now look at para 17. This is very important for the state government to think this. Before concluding, we think it necessary to recall that the state, hereinafter referring to both the union and the state government, is not a mere market participant, but a constitutional employer. It cannot balance budgets on the backs of those who perform the most basic and recurring public functions. Where work recurs day after day and year after year, the establishment must reflect that reality in its sanction strength and engagement practices. The long-term extraction of regular labor under temporary labels corrodes confidence in public administration, offends the promise of equal protection. Financial stringency certainly has a place in public policy, but not a talisman that overrides fairness and the duty to organize work on lawful lines. Moreover, it must be noted that ad hocism thrives where administration is opaque. And the State Department must produce this. And then the Supreme Court finally gives it and gives a direction that they must do this. This was also considered by the Supreme Court in another judgment. Just pass this. Similar plea was taken. Please look at paragraph 25. It's a disconcerting reality that temporary employees, particularly in the government institutions, often faced multifaceted forms of exploitation. While the foundational purpose of temporary contracts may have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligations owed to employees. And then the titles are there: misuse of temporary labels, arbitrary termination, lack of career progressions, use of outsourcing as a shield, denial of basic and benefits. Para 26, while Uma Devi sought to curtail, and then they said you can still do it in view of Uma Devi. So, para 27, last paragraph which I will read. In light of these considerations, in our opinion, it is imperative for the government department to lead by example in providing fair and stable employment, engaging workers on a temporary basis for extended periods, especially when their roles are integral to the organization functioning, not only contravenes international labor standards, but also exposes the organization legal challenge, undermines employee morale. By ensuring fair employment practices, government institutions can reduce the burden of unnecessary litigation, promote job security, and uphold the principle of justice and fairness they are meant to embody. This approach aligns with the international standards and sets a positive precedent for private sector to follow, thereby contributing to overall betterment of labor practice in the country. So this was what was it, and the most now January judgment of the Supreme Court finally concludes this. This is Bolanath versus State of Jharkhand, 2026 live law, Supreme Court, 95. Just a head note on the top. The Supreme Court set aside, does the Honorable Speaker get that? Set aside Jharkhand High Court's refusal to regularize contract employees who had served for over a decade in sanctioned posts, held the state as a model employer cannot exploit the unequal bargaining power of employees by keeping them in perpetual contractual roles to evade regular employment of them. Abruptly discontinuing long service employees based on contract and without speaking it was manifestly arbitrary. So, Honorable Speaker, which I want to point out is that when you are giving these type of assurances, I want to make them regular, I want to give temporary. You can't put those clauses by saying that this will still be contract, you will not have finality, and then you will be sent home. So this is what I wanted to point out, that you have to make these provisions in the budget so that you can have these things down.